Okay, thanks. Now the common law test that's been developed over time considers factors like whether the employer can hire or fire the individual, I should say the entity. Again, the direction and control, who's supervising the work, to whom is the individual reporting, what kind of influence does the entity have over the person. Number 5, again, is what the parties intended. And as Paul says, you know, if there's a clearly spelled out contract about what the relationship is, in some cases it's mandatory, in other cases it's really going to give you a leg up in terms of how the person will be viewed in these situations. Number 6, again, is the old profit and loss type test.
Let me give you a quick example of what that means. So in the moving and storage industry, where I have a lot of clients with independent contractors, we have a specific IRS ruling in the industry that says if you have a relationship with a contractor where he could walk up to the mover and rent a stake bed or rent a bobtail truck on a daily basis, and the mover owns the vehicle but, quote, rents it on a daily basis to the contractor, that is considered to be an indicia of employment and will disrupt the contractor agreement. Why? Because there is no risk of profit and loss, and the contractor only rents the vehicle when he's got work. So one way around that is if you have a monthly or a quarterly or an annual lease of a piece of equipment, then that's viewed as having financial risk because you're going to have to pay that rent irrespective of whether you have work on an individual day or not. So I just want to highlight that there are ways around this, and it's very, very fact specific. And that's why they have all these tests, because they look at the particular facts and circumstances of the entity in question. Sorry, Dan, go ahead.
Yeah, no problem. Paul, would you mind advancing the slide?
I'm sorry.
Thank you. Okay, so now under the Fair Labor Standards Act, which governs overtime and wages, the test is stated yet another way. And again, I'm not going to read all of these, but some of the same factors that we've seen before are here. You know, direction and control of the work, opportunity for profit and loss. One thing in the Fair Labor Standard Act test that you see in some states, but not all, is the permanency of the relationship. In some states, the duration of the arrangement has a bearing on whether or not the person should be deemed to be an employee. In other states, there are cases saying you can be an independent contractor for 18 or 20 years, and if you satisfy the rest of the test in that state, then the duration of the relationship really doesn't make any difference.
California happens to be one of those where the duration does make a difference, and
Right.
you need to track. And we'll show you some samples on how to do that in a few minutes. Track these contractor relationships so you can show that they're being renegotiated and there's an arm's length relationship.
Right. I won't say it's a bright line test, but some employers, when they're leasing employees, have a rule that the employees or the leased employee is not to remain in the engagement for more than 1 year, and that's because there's an IRS rule about doing discrimination testing for benefit plans. And that ruling says that if someone works a certain number of hours in more than a year, that even though they're employed technically by another entity, they should be included in the client entity's discrimination testing. So we've seen some clients using leased employees develop a rule where the person never stays a year or longer. They're always cycled out.
Yes, and on that point, if I could, Dan, there's a lead case that certainly applies in California, may apply nationally, called Viscanio versus Microsoft. And in that case, years ago, I think it was about a 1999 or 2000 case, Microsoft had contractors working side by side with others who were coding and doing data entry. And those side by side were employees. The contractors ultimately said they should have been employees. There was a big lawsuit. They won, and in the minute they won with the IRS, they should be employees. They went back after the benefits from Microsoft and said, gee, if I should have been an employee for one purpose, employment and W-2 income, I should be an employee for all purposes. Therefore, I should be entitled to all the retirement benefit plans as well as stock option plans. And they won on that theory. So now many employers will say, look, particularly with computer consultants, because I mentioned that statutory bar earlier, they will say, look, we're not going to bring anyone on here on a temporary basis unless they're on somebody else's payroll, and they want that insulation. So they come as temporary service employees on someone else's payroll. And that's a distinction that shouldn't be forgotten as you're looking at your own contractor relationships.
Right. Paul, could you advance this again, please?
Yes.
For those in the Ninth Circuit, which includes California, there was a recent July decision kind of consolidating the tests. And as we've talked about, there are a lot of different factors, and states and agencies pick their own grouping of factors as they see fit. There's some question in California because the California courts had stated the tests in various ways, what the test really was. And I think the Ninth Circuit kind of had it right, and they said, well, let's not get too hung up on what we call the name of the test. And they set forth 11 factors having to do with the hiring party's right to control the manner and means by which the work is performed. And a quick review of those factors are things like the skill required, the source of the tools, the location of the work. Again, as Paul pointed out, California looks at the duration of the relationship, whether the hiring party has the right to assign more work, how much discretion the hiring party has, the method of payment, who hires and pays for any assistants or other employees of the person performing services, whether the work is part of the regular business of the hiring entity, and as Paul just pointed out, that who's providing employee benefits, and what's the tax treatment. Although those last two figures may not be determinative, particularly if you misclassify someone, those are the areas where you're going to run into trouble.